John Farrell with the Farrell Law Firm. Today we're going to talk about whether you need a last will and testament if you don't have any children. But first, make sure you subscribe to the channel. We put out new videos almost every day. And make sure you hit the like button because, hey, every like helps. Today we're going to talk about whether you need a last will and testament if you don't have any children. As a baseline, a last will and testament is a legal document you create during your lifetime that will accomplish a number of things after you've passed away. The question is, do you need a will if you don't have any children? Well, let's flip that around. What makes you think you do need a will if you do have children? That's because one of the things that a will accomplishes is that it names a guardian for your children if you should pass away. Some states allow you to fill out a guardianship form, so you don't really need a will to name a guardian for your child, but many states, like Georgia, requires a will to name a guardian for your child. This person who you appoint to raise your children if you were to pass away is called a testamentary guardian. They are given the highest priority just under the natural guardians, which are the persons who conceive the child. So if you have children, it's a no-brainer to get a last will and testament. Otherwise, your local probate judge, a total stranger to most people, will be the person who decides who raises your children if you pass away without a last will and testament. So if you don't have any children and don't need to name a guardian for them, why would you need a last will and testament? Well, remember how I mentioned at the top of the video that a last will and testament accomplishes a number of things after you passed away? One of those things is determining how your assets are divvied up when you pass away. Without a will, the state will determine where your assets go. This method of determining who gets what is called intestacy. Each state has intestacy laws to determine where your assets go if you pass away without a will. If you have no children, then your property will typically be dispersed to other family members. But what if you have no other family members? Well, in those cases, it typically goes to the state. Let me tell you a story about a guy named Joe. Joe was a bit of a reclusive person. He lived in a modest home and drove a 28-year-old car. He wore old clothes and his neighbors knew very little about him. Joe never married and he had no children. He passed away at 87 years of age in 2016 without a will, which means the state would determine where Joe's assets would go. Once the state started to dig into Joe's assets, they were astonished. Joe, over his lifetime, had accumulated $11 million in various bank accounts, mutual funds, and financial institutions. Thus was born the largest unclaimed inheritance in American history. The state began to research Joe's family tree and found 119 relatives. Most he had never met or even knew existed, and some as far away as Europe who would share in Joe's assets. So, even if you don't have any children, you still need a last will and testament unless you're okay with the state determining where everything you've worked so hard for will go. By creating a last will and testament, even if you don't have children, you could pass your assets in a way that matters the most to you. Perhaps you want to help a partner or siblings or your parents. Maybe you have a charitable organization you care deeply about. Perhaps you have a beloved pet you want to make sure is taken care of if you were to pass away. A last will and testament can help benefit many other people and things besides family. Alright, that's all we have for today. Make sure you subscribe to the channel because we put out new videos almost every day, and make sure you hit the like button because, hey, every like helps.